hospitals have a gun shot wound in my chest.
All set? Okay, 6:01. Let's get started. I call this meeting of the Board of Adjustment July 9th to order. We can start with the roll call, Jamie.
Here.
Mr. Jones? Here. Mr. Mead?
Here.
Ms. Mergler? Mr. Rathburn? Here. Mr. Wolf?
Here.
Mr. Yagnik?
Yes, I'm here.
Mr. Galis? And Chair Elfman?
Here.
You have a quorum.
Okay, thank you. Bob, if you'd lead us in the pledge.
We all stand, face the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. Thank you. Entertain a motion for approval of the minutes.
So moved. Second.
Motion is second. Any discussion? Okay, Jamie.
Mr. Hagopian? This is
Yeah.
to approve the minutes.
Yes. Oh, sorry.
Mr. Jones? Mr. Mead?
Yes.
Ms. Rathburn?
Yes.
Mr. Wolf?
Yes.
Mr. Yagnik?
Yes.
And Chair Elfman?
Yes.
Passed 7-0.
Thank you. So for each member of the public out there that wishes to speak after each item is presented and discussed by the board, we'll have 3 minutes per item. Representatives of associations and groups will have 5 minutes. Call the first case, case number 25060002. And this is property address 1225 Ponce de Leon Drive. Let's start with any disclosures. Milton, do you have any? Samir?
Yes, I have driven.
Okay, and speak in the microphone when you can.
Do you need to be sworn in, Mr. Shine?
Oh, there you go. You're working now. Okay, Samir?
I drove by both properties.
Okay. Doug?
No.
I had a site visit and spoke to council. Bob?
Spoke to council and drive by it is item 2.
Jason?
Nope.
Pat?
No.
Okay. Andrew, you're on.
Good evening, Chair, members of the board. Andrew Shine, representing the property owner. Thank you all for coming out tonight. I'm sorry for making me come out just for my items. But the first is 1225 Ponce de Leon. This is an aerial of the property located in Rio Vista. And the variance is to enclose a carport. This is the oldest street view I can find. It's from 2008. This was the carport in question that the owner is seeking to enclose. And this board sees a lot of carport enclosure variances. They're pretty common, and they are common under this code section. And this is not why we're coming tonight. Generally, carports are allowed to encroach into the front yard in RD, RC, and RM zoning districts. So it's an allowable encroachment in these zoning districts. Carports, you can go to 15 feet. What happens is people come and they enclose their carports without permits at 15 feet, and now they're violating the code because garages cannot be into the front setback that far. This is not that situation. This is an RS zoning district, so this is not the same situation as other carport enclosures that usually come to this board. I'm not even certain that this carport required a variance under the non-conforming structure section, but we do know that it's the quickest way to get it done, so that's why we're here. When you have a structure that's non-conforming, you're allowed to make changes to that structure so long as you're not increasing the non-conformity. So, for example, if we needed a 5-foot setback and we have a 3-foot setback, you're allowed to generally stay at that 3-foot setback, but you can't go to a 2-foot setback. So you can't make it worse. And in this situation, we're not making the carport any worse. We weren't able to find original permits for this. The house was built in the 1950s, and the city's records in the 1950s aren't the greatest. But we did look at old historic aerials, and on the left is from the mid-1960s, where the house is in generally the same exact layout and it looks the same as it does today. We know the carport had been there since at least 2008. So we're comfortable with the assumption that this has been there for a very long time. And again, we're not proposing to increase the nonconformity, just to keep it the same. I do believe that there was possibly some discussions internally with staff on this because the real reason why we're seeking the variance, if we were told from the beginning, no, you can't enclose the carport, we would call it a day. But the city actually approved the permit to enclose this carport. On the top left, you can see the city's stamp with the permit number. I can't zoom in on here. I don't know if you can zoom in or if you just want to trust me. I'm on the record here. The carport says carport to be enclosed there, shows it at the 2-foot and change setback, and it was approved by the city. So I'm not sure if the city necessarily made a mistake in approving this because we weren't increasing the nonconformity. I think they were correct in approving this, but they did come back and say that we had to go for a variance for this. And it wasn't just a one-off plan page that they approved. This is a final survey drawing showing the carport to be enclosed as well with the city stamp. So the city issued a permit for the carport. So we signed a contract for the carport enclosure, got the materials for it, and then the city came back and said, we might have made a mistake. So that's why we're here tonight, is to get the permit reissued, essentially. We do have support from our most affected neighbor, who's a neighbor to the west. This is the support letter. We did reach out to other neighbors and not heard of any concerns with this. So our hardship here is that we relied on a permit that was issued by the city. And we do believe the permit was issued correctly, but the city came back and said it was issued in error. But regardless, this was all about reliance on the city's issued permit. Thank you.
Thank you. I see one person out there. Do you wish to speak to this matter? Or are you going to be speaking tonight at all? Okay. Thank you. So I do open the public hearing. Seeing the fact that nobody wants to speak at this point, I'm going to bring it back to the board for any questions. I am, if nobody has any questions.
No, just maybe ask staff, is it is, the applicant sort of alluded to the fact that there really maybe wasn't a need for a variance, but is that true or false? And I guess, did the city make a mistake? And not that it matters, but.
Don't let the colors fool you.
Yes, board. So what happened was, originally when the city issued the permit, we didn't have any problems with it. Then later on they came and did the addition at the back. So that kicked more than 50%. More than 50% if there is a requirement, if you are doing more than 50% in non-conforming structure, that needs to comply with today's code. So that's why when they added the addition to the original permit, that's why this came back and we said, listen, originally this was not there, but the addition kicked you into the 50% rule. That's why you need to have this. So that's what.
Does that sound accurate to you?
I'm looking at the.
I'm just trying to get the story straight.
Yeah, that's not my understanding. I'm looking at the plan page here stamped by the city, which shows both the addition in the back and the carport enclosure. So the evidence that I have doesn't suggest that.
Well, somebody's not telling the truth.
Andrew, I have a question for you. So you said that because when I went by, everything looked new because of the renovation.
Chair, just
go
to
ahead.
confirm, okay, because I didn't do the plan review, can you, just to make sure, the
Hold
correction.
my question.
When the plans were originally submitted, the back of the house had a very large porch across the back of the house. And the value of the porch was, when it was added into the rest of the project, it was not deemed to be over 50%. A revision was subsequently submitted and the entire porch was all changed to air-conditioned living space. And the cost of that is what bumped it over.
Okay,
Thank you very much.
thank you.
Thank you. Andrew, I have a question for you, unless if there's anything you'd like to respond to that. Okay. So when I went by, I know this is a big renovation. It looked like the carport, or what was going to be the garage, looked brand new from the beginning. Was that something that existed and it was just being prettied up to be a garage?
Yeah, nothing. The structure there is not new. It was taken down.
Thank you. And your microphone is dying out on you. So if techie folks back there, if we could make sure we have a microphone working for it.
We turn our mics off if we're not speaking. That's the issue here. More than 4, it's going to cut them off. So if you're not speaking, just have your mic off, please.
Okay, there we go. Okay. Thank you, Andrew.
Yeah, it was the bones of the house it's the same bones.
Does anybody else have any questions for the applicant?
What's the clearance? Find that the property line is 2 point whatever. What's the clearance around the side of this?
It's 2 point on the west,
Around the garage?
2.9 feet. Same as it was with the carport, 2.9 feet.
Anything else?
The garage is staying in the exact same place the carport was for what we believe to be 70-something years.
Yeah, that's correct. They haven't increased the existing area of the garage. The carport is the same as the garage.
Okay, do we have any other questions for the applicant? Okay, seeing none, I'm going to close the public hearing. Thank you, Andrew. There's no other questions. I'll entertain a motion.
Motion to approve the variance from section 47-5.31 table of dimensional requirements because the application meets the criteria for the granting of a variance.
Second.
Okay, motion and a second. Any discussion? Okay, Jim?
Yes.
Now my mic isn't working. Mr. Jones?
Yes.
Mr. Mead?
Yes.
Ms. Rathburn?
Yes.
Mr. Wolf?
Yes.
Mr. Yagnik?
Yes.
And Chair Elfman.
Yes, motion passes.
Pass 7-0.
Thank you. Welcome back, Andrew. We ready for the next one? Okay. Case number 25060004, 801 and 811 North Federal Highway. First, we'll start with any disclosures. So, Milton? I'm sorry, you don't have any and none? Okay, Samir?
I did drive by the property.
Okay, Doug?
Driven by the property.
Okay, and I'm going to be the same of drove by the property and did speak to the applicant's counsel. Bob?
I spoke to council and did a real quick drive-by this evening.
Jason?
Drive by.
Okay, and Pat?
Drive by.
Okay, there we go. You're up again. Your microphone's off. There you go.
Good evening, Chair, members of the board. Andrew Shine here representing the property owner. I also do have the property owner, Andrew Shader, in the audience as well. The property is located at 801 to 817 North Federal Highway. Anyone who has come out of Holiday Park has probably seen this property. Just a brief history of the property. This was the last tenant to occupy the property. It was a mosaic and tile store in June 2015. And it hasn't been vacant for lack of trying to find tenants. It's been vacant because the building is, I'll use nice words here, it's not a very nice building and the layout of it is not conducive to business in 2025. And we'll look at an overall plan of it. In July, the property was sold in January of 2016 to a new owner. This is from July 2016. It is still vacant. And the owner was trying to rent it out at that time. You can see available signs everywhere there. Later, July 2017, still vacant. July 2018, still vacant. March 2019, still vacant. In February, it's still vacant, and it was sold in August of 2021 to the now current owner. Some exterior, it was painted. It was very minor modifications were made, but it was, they attempted to rent it out, and again, it's just not a building conducive to business. So, October 2022, still vacant, and the present day, it's still vacant. The proposal for this is to make it a little bit nicer of a building and to make it more functional. And there's currently a plan in the Development Review Committee that looks like this, to renovate the facade, raise the parapets, and to just make it a lot nicer of a building. I do want to say that Board of Adjustment is not the last step. If this does get approved tonight, this is not the last step. We are still in the Development Review Committee. They're going to be commenting on design, layout, anything that we're not asking for a variance for tonight, which is we're not asking for. That's all right. We'll get it fixed. But this is not the last step. We're still in the development review committee, so they'll have plenty of comments for us. Unfortunately, I do need to show the next slide to talk about it. I'll talk about it without it. The next slide is a code section on the termination of non-conforming status, which we hinted at a little bit in the last application. And there are two main ways that a property can lose non-conforming status. Here it is. You don't have to read this. The one way that a property can lose non-conforming status is if the use is discontinued for more than 180 days, which the use here has been discontinued for almost 10 years. So we lost non-conforming status in that regard. And the second is if 50% or more of the value of the structure is removed, or if you're doing improvements that are more than 50% of the value. The structure is somewhere around $600,000 in value right now, according to the property appraiser, and the owner is putting more than that into the renovation. So it definitely exceeded 50%, and we'll lose non-conforming status in that way as well. And with the loss of non-conforming status, this project is located in the Regional Activity Center. So it's subject to a lot of extra requirements that other properties are not. And when you lose non-conforming status, you have to bring the property into compliance with the current code. If we brought the building into compliance with the current code, everything within these red lines, everything outside of the red lines would need to be demolished. So it would be a full demolition of this building, essentially, if we had to bring the current property up to code. And the reason is part of the downtown master plan, which requires most setbacks are from the property line. In the master plan, your setbacks are from the center line of the adjacent street. So on the west, if we had to bring this into compliance, the new building would need to be 35 feet from the center line of the west street, 35 feet from the center line of the south street, and 70 feet from the center line of Federal Highway. So that would necessitate fully demolishing the building and building between a 20 and 25 foot width building, which again is it's not attractive for tenants. It's not a functional building. And while it could be built, it's just going to remain vacant still if the building had to look like that. This is a survey view. Everything in the outline of the red boxes are the current property lines, and the red is what could not be built upon if the building had to be brought up into compliance today. We would lose a significant portion on the actual building itself, which was shown on the last slide, and the parking lot would also have to be fully brought into compliance with stacking. So we would need to have 20 feet on the west, which is on the top of this page, and 20 feet on the east, which is the bottom of this page, for vehicle stacking. So we couldn't have any parking there. So we would lose a massive amount of the building and at least 6 out of the 11 parking spaces that are there if it had to be brought fully into compliance. The reason that this property is in such a bad position with compliance comes from the downtown master plan. This is an excerpt from the downtown master plan, which if you could see on the top right, you could see where the property is. And I don't know if we need to zoom in, but if you see the dashed red lines that are going north to south, that's Northeast 5th Terrace, which in the master plan was proposed to be vacated. So what the city saw, let's see if I can go back to an aerial. Sorry, we're going back a little far. So if you can see all of the properties along Federal Highway where this property is, they're substandard lots. You can't build much on them. So when the city did their master plan, they encouraged the vacation of Northeast 5th Terrace so that the properties can be combined into a bigger developable lot. Unfortunately, this property was kind of left in the dust compared to other blocks. So this is one block to the south where you can see the majority of Northeast 5th Terrace was vacated. The commercial buildings that are on Federal Highway were able to be pushed back because they had the space at this point. Now that Northeast 5th Terrace didn't need to be taken into account. They don't have to be 35 feet from the center line. They don't have a setback from the street at all there because it's an internal driveway. On the northeast is a property similarly situated to this one, though. 2 blocks south, same exact situation. Northeast 5th Terrace was vacated. There's going to be 2 beautiful new high-rises on the west there, and the commercial buildings were pushed back because now we don't have to worry about Northeast 5th Terrace. The property on the southeast is similarly situated to this one. These are in a little bit better of a condition, though, since Northeast 5th Terrace was mostly vacated. So if they go to redevelop, they shouldn't have too much of an issue vacating that. Here, where this property is, Northeast 5th Terrace is not vacated at all. 3 blocks south, I think this is the Manor. Again, similar. Northeast 5th Terrace was vacated in accordance with the master plan. Commercial buildings pushed back. And 4 blocks south, the exact same thing. So all of the 5 blocks that the city suggested Northeast 5th Terrace be vacated, 4 out of the 5, they were vacated. With this one, it was not vacated. And unfortunately, it can't be vacated anymore. The project, I don't know what it's called now. It was called Madeira 555, is highlighted in green. And they were unable to, it was prior to this owner, but they were unable to get the owners on the east side to agree to vacating 5th Terrace. So both owners have to agree. So they built their building without vacating 5th Terrace, which put the buildings on Federal Highway in a very poor position because now they have substandard lots that they cannot redevelop, and that's why they look like how they do today. I'm going to go through the variants. There are a couple of variants. There are, I believe, 5 variances on the agenda. They're all related. The first 2 are for non-conforming, not to allow us to retain our non-conforming status. And essentially what that would do is allow the existing part of the building to remain where it is. The facade can be renovated, but nothing has to be demolished. Everything new that's going to be done will still have to meet code. So the non-conforming things that we're requesting are just for the existing building. There's the parking lot variance that we have for the bringing that up to code. We would lose 6 out of 11 spaces there because the parking lot would need to be fully brought up to code, which today it's not. It's a functional parking lot, but it doesn't meet all of the stacking, which are like when you're waiting for a car to pull in or out of a spot. It doesn't have all of that part doesn't meet code, but the parking lot still functions. I will go through the variance criteria on this one because I do think it's important. Let me just grab my notes. So the first criteria is that special conditions exist which prevent the reasonable use of the property. As noted before, the property got left behind when everything around it was redeveloped, and that can't be undone at this point. Requiring the building to be demolished and rebuilt in an unreasonable way is unreasonable on its own. And even if they were able to demolish it, finance a new building on there within all of the required downtown setbacks, the layout wouldn't be reasonable, and we'd likely still be having another vacant commercial building for another 10 years. The next criteria is that the circumstances are peculiar to the property at issue or to such a small number of properties in the zoning district that it's a market exception. I did note before there are 3 other similarly situated properties out of hundreds and hundreds of properties in the downtown. This one is a little bit worse than those because 5th Terrace is still there in full. But even if we considered the other 3 out of hundreds is clearly a market exception. This one I'm going to read in its entirety. It's a little long. That there's a deprivation of a substantial property right enjoyed by other owners in the same zoning district. And this next part is very important. It shall be of no importance to this criterion that a denial of the variance sought might deny to the owner a more profitable use of the property, provided the provisions of the ULDR still allow a reasonable use of the property. I'm not going to sugarcoat it. Yes, allowing this would be a more profitable use of the property. It's a nicer building, it's a bigger building, and they would probably actually be able to rent it. So it would definitely be a more profitable use of the property. But that second part is provided the provisions of the ULDR still allow a reasonable use of the property. And that's our issue here. The provisions of the ULDR don't allow a reasonable use of the property. If they could have rented it in the last 10 years, they would have. Nobody wants to sit on a vacant commercial parcel without tenants. They were trying to rent it. This owner trying to rent it, the previous owner was trying to rent it, and the one before that, after the tenant left, was trying to rent it. But it's just in 2025, it's an unreasonable building for business. So yes, I will say this is a more profitable use than the current vacant property. But that second part is important because the provisions of the ULDR do not allow a reasonable use of the property here. Our favorite one, that a unique hardship is not self-created by the applicants or his predecessors, nor is it a result or disregard for or ignorance of the ULDR. This hardship of being, frankly, unable to develop anything on the property that makes sense here it comes from the adoption of the master plan, which required setbacks to be measured from the center line of the adjacent rights-of-way, making this redevelopment here unreasonable, if not impossible. And they did carve out that right-of-way exception where they said, we understand these lots are substandard. That's why we are encouraging everyone to vacate Fifth Terrace. That carve-out worked for all of the other blocks, but in this one, unfortunately, the property to the west was already developed by the time this plan came through. So now we can't vacate Fifth Terrace, even though it's preferred by the city to do so. So the hardship was created just by the adoption of the master plan and the pattern of development around the area that didn't allow us to use the master plan. The last criterion is that it's the minimum necessary to make possible a reasonable use. And our answer to this is we're not asking for anything extra here. Anything new will have to meet code, whether it be landscaping. The new part of the building is going to be at those required setbacks. We're not trying to get around that. All we're asking is that the building shell as it exists today can continue to exist and we can improve upon it. I also want to say that I might be getting a little sentimental here. I live in Fort Lauderdale and I work 2 streets to the south of here. I don't think this is just a hardship for the property owner. I think this is a hardship for the city. With the Iceplex, the Parker Playhouse, and everything going on at Holiday Park, the first building people see when they come out of Holiday Park is that. And it's not pretty. But the previous owner couldn't find a way to get it done, and this current owner was willing to take the risk, knowing that we might be in front of the Board of Adjustment for variances. But I do truly think that if we can't find a way to get it done, keeping our non-conforming status, I don't know what would ever be built here. And, we have the history showing it's been vacant for 10 years. There's no reason to suggest that would be any different in the future. And I at this prominent corner, I think it's a hardship on the city as well. Thank you.
Thank you, Andrew. At this point, I'll open up the public hearing. Is there anybody from the public wishing to speak to this? Okay. In that case, let me bring it back to the board. Sure.
We have 5 requests for variances in front of us. They have to be taken up sort of in use or all at once, or how are we going to do this?
Dwayne, I'll take your advisement on this.
So I would recommend that you take them each.
Can we do the 2 non-conforming status together?
You can. I do have some suggestions with regards to that particular variance. So we understand what the applicant wants to do in terms of allowing the code provides for if they expand over a particular threshold that it terminates their status. They're attempting to protect that status. We want the order to reflect the protection of the existing building as he's put on the record, so that that if they move forward or try to do any additional changes, that they are still subject to this code provision. So unlike prior variances where you would waive the variance, it runs with the land, the code section is waived for any future development. We want to make sure that we meet the intent here, which is, hey, we recognize that this is legal nonconforming. This is not a termination of the legal nonconforming status of the building, but it's just allowing for this one-time expansion on the nonconforming structure. So that simply can be done by acknowledging and adopting the variance for this termination of the non-conforming status, that the existing building remains non-conforming.
Does that answer your question, Bob?
Yes.
Okay. Is there any questions for the applicant, Pat?
Yes. Andrew, there's a couple of parts of this that you didn't talk about, and that's the landscape requirements. Can you just touch on that?
Yes. So, and it's landscape and streetscape really. The master plan prescribes for. Actually, did I put a landscape plan in here? It's in the. There's a landscape plan in the backup. The master plan provides for streetscape design, which is one of the variances, and part of that there are a couple parts of streetscape design. One is the setback, so being 35 feet or 70 feet from the center line. The other part of that is landscaping and right-of-way landscaping. So if we had to meet the right-of-way landscaping requirement, the east part of this building would have to be demolished, and the sidewalk would need to be flipped, and landscaping would need to be put between the sidewalk and the street. So it's not really specific to the landscaping, I would say. It's specific to the streetscape design. I do see how they put it on the agenda. It says rack landscaping requirements.
So what
I
is
don't
it?
know why it's on as rack land. So the rack landscape, I get why it's like this. The rack landscape requirements are in 4713.20.G, but all they do essentially is refer to the other part of the code, which is 4721.12F. So it's rack landscaping requirements, but it relates to both streetscape design and the vehicular use area. So I don't know that we're really violating any landscaping requirements per se. We are not bringing the parking lot up to current code. And some part of that is landscaping, but that's not the biggest issue we have with the parking lot.
And that goes to the next two, which is the streetscape design and the subdivision layout.
Yes, the streetscape design, that's where the setback requirements are found. So the 35 feet and the 70 feet from the center lines that I was touching on, that's where those are found in the streetscape guidelines. And the last one I did not speak about. The last one is just right-of-way dedications. When you do a new building, you have to dedicate right-of-way to either DOT if it's on federal highway or the city if it's on the other streets. We are still going to have to work this part out with DOT because that's the real issue. But on the right, if we were on the plan east on the right here, if we had to comply with the dedication requirements, we would have to grant FDOT right-of-way over a building, and FDOT won't take right-of-way with a building on it. So we would have to demolish that and then give the right-of-way to FDOT. That's also related to the streetscape guidelines. These are all, they look like separate variances, but they're all interrelated. That we don't know what FDOT is going to say about that, whether they're going to require us to do it, and we might have to do some type of license agreement with FDOT. But this is just to allow us not to have to knock down the east part of that building to give right away to DOT.
So if we, Dwayne, if we grant the variance saying that they don't have to give the right of way because it would have to tear down part of the building, that's not going to be binding on DOT if they decide they want it, is it?
It's not.
Okay.
And we recognize that risk.
All right.
We are granting DOT right-of-way north of this. So again, everything else will meet code. So we'll be granting DOT right-of-way to the north of this.
Okay. Thank you.
Jason.
Yeah, just I think you've made a compelling case for the project, but I don't want to kind of state how important the downtown master plan is and why it's there and what it has created in that whole area. I understand that this specific property, you kind of alluded to the fact that it was kind of left, behind, but you do have several other properties to the north. And, I think there is a development project that could happen here on this narrow site. This could have been a larger rebuild project. A variance could have been asked to make a smaller setback to allow you to put a different type of a building on this property. So part of me says, like, you know, we can, this is like a very big set of, you know, we're basically kind of trying to fit this, keep this square peg in this kind of round hole that it doesn't, to me, it doesn't really belong here. But would I rather have seen you come and say, hey, we're asking for a variance to reduce the rear setback because we want to build some structured parking and a live work, you know, 5-story building that's more in line with the other development that's here, because I know it's zoned for that at least. You know, I think that would have been a better use of this property. I understand that the client has purchased this property and is trying to make it work. But I also think, for me, it's really important to honor the master plan, because that's the reason why it's there.
Can I make 2 comments on that? The master plan has dozens and dozens of design guidelines and things to do. We're not asking for a variance from those. We are still going to have to comply with all the design guidelines. Everything else that's in the master plan we have to comply with. It's just the setbacks that we're really asking for here. And the comment on structured parking, I wish the scale was a little bit different here. We're talking about something that's 20 to 25 feet in width. A parking space is 18 feet in length. So we can't even fit, and you have to have at least, an 18-foot drive aisle next to it. So we can't even fit 1 row of structured parking on here. This is a very, very small site. So,
right, but there could be a project where you ask for a variance where you get a slightly wider area to build on. I mean, I don't know what that hypothetical project looks like, but you know, as an architect, that's the one thing I'd be saying, like, hey, let me look at this site. How can we get some space? How could we get the parking? How can I create a project that, you know, for the person that owns this property could be worth millions and millions and millions of dollars.
Okay. Do we have anything else for the applicant? Seeing that we don't, I'll close the public hearing, and I will entertain a motion from the board. Just put on your microphone and see the best you can do. Dwayne, I think, has a question before you do.
Yes.
Or a comment, actually.
Not a question, but with regards to those first 2, the language that I would suggest would be added to the usual language with regards to meeting the criteria that granting these variances do not affect the legal nonconforming status of the existing structure, which will remain subject to the provisions governing nonconforming uses and structures, with the exception of the additions indicated in the backup.
Did you get all that, Bob?
Yeah, recording secretary is hastily typing that. We'll put that, you want that at the end of it?
Yes.
Okay. I move, Mr. Chairman, to combine the first 2 variance requests. The first one, Section 47-3.8A1, termination of nonconforming status, to allow to request a variance from ULDR Section 47-3.8A.1 to allow legal nonconforming structure that is altered to more than 50% of the replacement value to retain its legal nonconforming status, and combine that with the second variance for Section 47-3.8A.2, termination of nonconforming status, in approving requesting a variance for ULDR Section 47-3.8A.2, if I'm saying that right, to allow a legal nonconforming structure with the discontinued use to retain its legal nonconforming status, where the ULDR terminates its legal nonconforming status, and then with a note to include the council's comments at the end of that motion.
Okay.
And we'd have to reread the whole thing, but I think
Unless there's objection from council, if you need me to reiterate.
No, as read as the record.
Okay, thanks.
And before we ask for a second, Dwayne, do we need 2 different motions, one to combine and then one to approve?
No, it's fine.
Okay. Thank you. Do we have a second?
I'll second it.
Okay, motion and second. Any discussion? Okay. Jamie, it's on you.
Mr. Hagopian?
No.
Mr. Jones? Mr. Mead?
No.
Ms. Rathburn?
Yes.
Mr. Wolf?
Yes.
Mr. Yagnik?
Yes.
And Chair Elfman?
Yes.
Passed 5-2.
Okay, entertain a motion for the next two. Not necessarily combined. We could do one by one. Next three, sorry. I already turned the page. So with that, Pat, did you want to?
Yeah.
Go ahead.
I make a motion to grant the variance request from 47-1320G, 47-1320H, 47-24-0.5 D1 for landscape requirements, streetscape design, and subdivision layout as the applicant has set forth the criteria for the granting of a variance per the ULDR.
Motion and a second. Any discussion? Okay, seeing none. Jamie?
Mr. Jones?
Oh.
Mr. Mead?
No.
Ms. Rathburn?
Yes.
Mr. Wolf?
Yes.
Mr. Yagnik?
Yes.
Mr. Hagopian?
No.
And Chair Elfman? Passed 4-3. Oh, no. Needs 5 to pass, so it failed.
Okay, did anybody want to make a new motion? Okay, seeing none. Thank you, Andrew. That was fail. Last three.
Oh, I'm sorry. You combined all three on that last motion? Oh, okay. No, I mean it's your per.
I can do a new motion. I think I wasn't on the prevailing side, so somebody on the prevailing side has got to do.
No, it's fine. It's fine. I was just not paying attention, and but other members you do have the prerogative to raise motions on the other items individually if you want to do so, but.
If I just can say, 3 is kind of a separate one. 4 and 5 are related. They're almost the exact same thing as 1 and 2. So I don't know how it's going to work at the city if 1 and 2 pass, but 4 and 5 don't. That'll have to be interesting.
Because 4 and 5 are the ones that say how far back you need to go, right?
Right. So,
Yeah, so this building, as it is currently constructed, cannot possibly meet the setbacks required by 4 and 5.
right. If 4 and 5 fail, then the building gets
Right.
demoed.
So
Same
if
as
we-
1 and 2.
so
3
if
is
we-
separate.
Yeah, if we were going to give you non-conforming status, allow you to continue that, which we just did, then in order to make that not be nonsensical, we have to grant 4 and 5.
That was my understanding. How I originally applied was only 1 and 2 in this. The city attorney asked me to put some more specific requests in there. So yeah, it's voting yes with one hand, voting no with the other on
Yeah.
4 and 5 and 1 and 2. But
So
I just don't know how that would actually work.
is there someone that was on the, did they have to be on the prevailing side, Dwayne?
No, what happened, it was the motion failed, and
Right.
so you
It's
can
open to a
entertain.
totally new motion?
Yeah, you can, yes.
Okay. All right. I'm going to make a motion on 4 and 5, which is section 47-1320H and 4724.5 D1, to grant the variance as requested because it would be inconsistent to not do so with the previous granting of the non-conforming status in order to allow the building to retain its existence as a non-conforming building. Those two provisions are necessary, and I believe the applicant met the criteria.
But could I just ask that, well, wouldn't we then redo the first motion because that's not consistent with the second motion?
I'm sorry, I'm not following.
I don't understand the revoting. If we voted, I'm not understanding voting again on the same thing we just voted on.
You're not, it's a different motion. So my understanding that the second motion was for 3 code sections.
Yeah.
And then the current motion is for 2. So if it's not seconded, then you have nothing to vote on, but there's nothing that prevents, it's a different motion.
Okay, so we have a motion on the floor. Do we have a second?
Second.
Okay, we have a second. Now, any other discussion?
Well, the discussion is if the first pass means you can keep the building, as opposed to the second pass means you can't do the new building. They're 2 different things. No. They're not the same thing.
My understanding, and you guys, the first one says you can keep the building.
Right.
The second one is you can't make any improvements or you can't do anything.
To clarify,
Okay.
the first 2 motions, you have a legal non-conforming structure. They can keep the building now. They just can't expand on it. They're proposing to expand on the building, but if they do, the code section that you're giving them the variance from would terminate their legal non-conforming status and require them to meet code completely in terms of whatever they develop on that site. So what you've allowed them to do based on the drawings that they've submitted is allow them to expand without terminating their legal non-conforming status. Now, these other requests are added to address the site requirements of the new structure with the expanded additions to allow it to be constructed on the site and accommodate based on the existing conditions there.
And I think it's important that, part of it, when you're talking about expanding the use, part of it is you're not building anything new, but because of the value of what you're redoing, that's considered more than 50%.
It's a mix of both. There is a proposed addition. The proposed addition is going to fully meet current code, downtown master plan, everything. That's the new addition. The existing does not meet code right now. So you guys just approved that it can retain its non-conforming status. And I guess this is a question for Dwayne. If we retain our non-conforming status, even if we're doing more than 50%, which we are, is now approved, how would something like a right-of-way vacation on federal highway work? I think we're already exempt from that since the first 2 were approved, but I think it would give staff a little less of a headache if 4 and 5 were also approved. So when you're doing a new building required to meet code, one of them is right-of-way dedications. But we just got the variance for the nonconformity for the 50%. So,
but as you stated, the variance request deals with the existing structure, and that you said the additions will meet the code requirements.
Yeah, we're not asking for a variance on the new structure. The variance language itself says the existing streetscape adjacent to the existing building. I guess we could say abutting the existing building. We're not asking for any variances for any new addition. So maybe we won't even need 4 and 5.
Well, that would be for staff to determine whether or not the new additions completely meet the code provisions in terms of landscaping and so forth.
Yeah, of course. I'm saying, do we even need 4 and 5 if the new addition is going to meet code?
Well, that's what I'm saying. I'm not the plans reviewer. I don't know what they required of you when they reviewed your plans. I assume that they reviewed your plans and said you need to meet these particular criteria, and that's why you're seeking the variances.
We got ahead of it. We did we looked at it on our own. I guess I could ask the zoning administrator. He's close by.
again, as we said, when we had the discussion, I know you went ahead with it. I don't think we had reviewed it that way.
Right.
So at this point, it's very hard for me to, comment on what they're asking.
Well, no. It's a simple question that I'm asking though. We got the variance that we can retain our non-conforming status now, so we can do an addition, even if it's above 50%. We can retain our non-conforming status on the existing building.
Are you going to meet the landscape requirement for the addition?
On the new part, yes.
On the new part?
Yeah.
And the parking requirement for the new part is in compliance?
If 3 failed, so yes, it will have to be brought into compliance.
Okay. So, if you're in compliance with the code, then you don't need the 3 and 4. But if you're not in compliance with the other sections of the code, you need this.
Okay. The new addition will be completely in compliance. The existing will retain its non-conforming status.
So I understand the discussion that you're having, and I just want to be clear that even though he's stating that on record, I don't want you to go ahead and rely upon that, saying, well, you said at a public hearing that this is so without having actually reviewed the site plans and so forth.
Understood.
Yeah.
Understood.
Dwayne, question, unless it's out of character. I know we already voted. I know we can bring it back up if we choose to with the new motion. But if we are arguing about whether 4 or 5 are needed or not needed, are 4 and 5 itself able to be withdrawn and brought back if needed?
They can. Well, so even though I was telling you that you can bring another motion to consider those things, the lack of the failure of the approval of the motion to approve the 3 is a failure, and it may trigger the 2-year restriction on bringing back a variance.
That's part of why I asked.
Can the losing side do a motion to defer at this point for 4 and 5?
So it's usually the prevailing side.
Sorry, can the prevailing that's what I meant. Can the prevailing side do a motion to defer 4 and 5?
A motion to reconsider, and I think procedurally a withdrawal of the motion at the time that's on the table would work, I suppose.
Okay. We voted on 3, 4, and 5 together.
Correct.
So if someone on the prevailing side, which was the side that voted no, made a motion to reconsider, we could reconsider 3, 4, and 5. And then we could say, once we approve that motion to reconsider, then we're back to square one, and we can make a motion individually on 3 and on 4 and 5. And that motion could be to defer 4 and 5 to a subsequent meeting to give Andrew the time to determine whether he needs 4 and 5.
It's going to be a discussion with me and staff.
Right.
It's a zoning interpretation at the end of the day.
So I would like to see somebody that voted no to the combined 3, 4, and 5 make a motion to reconsider the vote on that.
And sorry that I keep talking, but I only submitted with 1 and 2 because I thought 1 and 2 were the only ones necessary to get this done. So it sounds like there might still be some disagreement on 3, 4, and 5. So I do think we can go back to the drawing board with staff again. I originally only thought 1 and 2 were necessary to get this done.
Yeah, because unless we do the motion to reconsider, he's dead in the water for 2 years.
So is there anybody that was on the prevailing side which voted no that would reopen this for reconsideration of the motion? Okay. Then we see that remains as it is. We did 3, 4, and 5 in there at the same time?
Yes.
Okay.
All right. Thank you all.
There you go. Thank you. Before we get for communication to the City Commission, I did want to recognize that Jared Galis did come in. He was a little bit late, but he did come in around 6:15. Is there any communication to the City Commission? Okay, before we go for the good of the city, there's a presentation on the amendments to the Board of Adjustment process, and that will be done by... Hey, there you are. Sorry. It's like, where did you go?
I'm right here. Good evening, Chair and members of the board. Carlanne Devonish with Development Services Department. It's interesting that I'm actually bringing this presentation to you because some of the points that you just went over, you'll see that I'll be discussing. So today's presentation will focus on a few items that the City Commission requested for staff to gather information on and bring forward for them to give staff direction on moving amendments forward regarding Board of Adjustment appeal processes and other things. Yes. So you'll see. So some of those discussion points are on administrative variance, the voting requirements currently for the board, and the current appeal process. So with the administrative variance, this discussion point was brought to the Commission's attention when a neighbor did a presentation at a conference meeting in September of last year regarding the administrative variance, because she was informed that a simple gate installation to add to an existing legal nonconforming wall would require her to go in front of you all for variance. And after meeting with staff and understanding the variance process, she felt that it was just a bit too burdensome and expensive for such a minor request. And so she brought a presentation in front of the Commission requesting the Commission to consider implementing the administrative variance as part of the ULDR. And so the City Commission at that point requested for staff to conduct some research and provide recommendations. So a lot of the requests throughout the state from different municipalities have different elements, but for the most part, a lot of administrative variances are for lot area, lot coverage, structure height, number of parking spaces, landscape requirements, and of course, setbacks. And as you all are aware, a lot of the variance requests that we receive are for setbacks. And so we did some research throughout the state. Some of those municipalities that we reviewed took a closer look at would be for City of Miami, which has an administrative variance for up to 25% relief for yard setbacks on existing buildings. In the City of Port St. Lucie, applicants are able to get a relaxation of up to 3 feet or 36 inches for height and yard setbacks, again for existing structures and existing principal and accessory structures. In Punta Gorda, there's a relaxation for up to 10%, again for existing structures, and this would be for yard modifications. And in Jacksonville, it was a point system, but it was still the same process of being able to add enough points so that you're able to get an administrative process, an administrative variance. And so the recommendation that we brought in front of the Commission was, and I'm sorry, I should have said we did bring this in front of the Commission May 6th of this year, so a couple months ago now. So the recommendation was to apply the administrative variance only to existing single-family residential dwelling and accessory structures. So this will not be applicable to new constructions or folks that will not necessarily have proof that a permit was pulled. And we originally suggested 10% or 1 feet, whichever is less, for yard setbacks and structure height. But the Commission did provide feedback to make that to be 25% or 3 feet, whichever is less. In terms of the review process, the application would go to the zoning administrator's office, and existing variance requests would be applied. So the same existing criteria that is applied now would be still applied for the administrative variance. And if the variance were to be denied administratively, then the applicant would be able to come to Board of Adjustment to appeal. The next discussion point is on the voting requirements. So as you all know, the existing requirement is for a majority plus 1. This aligns with other major items throughout the city that will be such as sale or lease of property, city property, or rezoning to a planned development district. We believe that the supermajority was imposed on BOA because it is a higher approval threshold and it is a burden of proof. I mean, it is a variance to not meet zoning requirements, so of course there would be a higher approval threshold. So we believe that's why it was originally put in the code for a supermajority vote. However, applicants' feedback is that it's just a little bit too burdensome, and so a majority vote has been requested, and the City Commission did support that suggestion. The next, go ahead, sorry. Seven.
Correct.
Simple majority.
Okay. So the next discussion point is on the appeal process. And so currently the appeal process would be for applicants to go to circuit court. This is also a request with applicants' feedback saying that is just a little bit too burdensome. And so the suggestion was to bring appeal in front of the City Commission to review as a quasi-judicial hearing to determine if the Board of Adjustment appropriately applied the criteria to make their determination. And the City Commission did support that recommendation, and so that would be the amendment moving forward. We shared the statistics here with the commission, and so I left it in. I'm pretty much presenting the same thing that I did with the commission. So, did you? Yes,
That's correct. Yes.
That is correct. So, hold on. There is a point for that. So these are not. This portion is not really for suggestion because City Commission already gave direction for this portion, but there is a bonus portion that I do need your feedback on. My bonus point, yes. So I did share the statistics with the commission just to show that we did not receive a lot of appeal requests within the last, 5 years? I believe we've only brought 5 in total throughout. I'm sorry, 3 in total since 2021. And this is as of April of this year. I'm not sure if an appeal was submitted since then. Go ahead. Mine either. So. It could have been.
I mean, they had to be.
Because those are the 4.
Most likely they were deferred. And again, this is from April, so.
Deferred or withdrawn?
Well, withdrawn is 0.
The withdrawn is 0.
They were deferred for the next, most probably. Shaquille, am I correct?
Well, no, we don't have anything being deferred to the next meeting, so, and it's not a big deal. It just didn't add up.
All the other ones add up.
So most likely it was deferred. Again, this is from April, and so you probably heard it in the last couple of months.
All right, thank you.
No problem. So this is a bonus point that we do need your feedback on. So this is regarding the successive application, actually what you just brought up with Mr. Shine, saying that if there was a denial for one of his requests, he would have to wait 2 years. This is another point where the applicant felt that 2 years was a bit too long. And so we are looking for your feedback on suggestions for this. I did put a few options up there, and we can a la carte it if you'd like. So one suggestion would be to reduce it down from 2 years to 1 year. Another would be to limit the number of successive applications to possibly requesting maybe up to 2 times within a time frame. So applicants, it's several, but I don't have those numbers. I'm just a messenger.
I read it like, okay, somebody who lost a hearing is complaining. One person.
And it could be throughout.
I was just trying to think of, what statute means not allow it in your coastal that they got upset about or whatever, but it's coming across as one person objection.
No.
2 years is bad at all.
Okay.
Makes them turn in their paperwork.
Okay.
Depends on, if I may.
Go ahead.
If it's 2 years for the same thing, that's one thing. But if they come back and say he lost and came back with a different plan, he's be able to come back because he's rethought it, said they didn't like that, let me come do it. Is that the same 2 years or is that a different?
That would be a different request.
It has to be
No, actually,
substantially
it would,
different. It has to be
based on
substantially different.
based on the language now, that would be barred under the 2 years. So I think there's some room for altering that language to clarify that the successive applications, that there has to be substantial changes between it, because what the language says now is a 2-year wait period before an applicant may submit an application for the same or substantially similar application as that which was initially denied.
Right, if someone comes and says, I have 5 feet and I want to get down to 1 foot, and they get no, and they come back and say, well, instead of getting a 4-foot variance, I only want a 1-foot variance, that's substantially different than you should be able to come back.
We would consider that substantially similar. For example, if they're looking to get a variance from this side yard setback, to us it doesn't
Especially if it's the
matter
same
if
side yard. You
Yeah,
know
if it's
what
the
I mean?
same side yard, it's the same variance request.
One way they're asking for the world, and then something they're asking something more reasonable. That shouldn't have to wait 2 years to do that.
That is exactly the issue that we're wrestling with. So we're the issue that this was trying to avoid is repetitive requests to you that aren't, what you would consider substantially different. But how to encapsulate that is kind of the question. How do we do that? Because obviously but we have a difference in what we consider substantially similar than what you've stated in your example as being substantially different.
How did 2 years originally come into play?
It's been in the code for a while, but it is to avoid those circumstances where someone gets denied and comes back the next month, and then comes back the next month, and then comes back the next month.
Okay, so to answer your question, I would put a percentage on that. If, let's just say the rule is X feet, and they wanted 75% of what's legal, and then they knock it down to 10%, we can put something in there.
So you're suggesting not changing the 2 years, just defining what substantially similar is?
Changing the 2 years, if someone changes what they're doing to makes it more acceptable to the board to approve, they should not have to wait 2 years. But to establish that you're allowed to do that within the 2 years would have to be a substantial change, but that would do on a percentage basis. So changing it 2 inches doesn't count, but changing it, you're doing 75% less asking than you did the first time on whatever the dimension is, would seem like a reasonable change that might bring it into where people would accept it as a variance.
Okay.
Are you suggesting no limitation then? So so completely eliminating the 2 years, but having the applicant being able to come in with a significant change.
Only twice.
Like if they had,
So
they
you
were asking for like 7 variances maybe, and then they want to come back and they've redesigned it, and it ends up only being 1 variance. I mean, I would consider that to be a significant change.
Yeah. I mean,
But they're still asking for the same variance that was denied, so it's not a change.
Well, it is a change. I mean, asking for different things is, if you're asking for a 25-foot setback on the front, and you went from, I want to put my garage 10 feet away, okay, which people may not like, to, oh, I want a foot over, I want a 1 foot variance, that's a substantially different ask.
Yeah, but
Just because it's the same variance of the same rule, what they're asking for is very, very different, and they had to go back and redesign.
It could also be like the collection of variances that's being asked, like in this last example, there were 3 that was packaged together. If it were just one, the outcome could have been different, or if they came back and just said they just wanted ask for one variance.
But see, if you didn't change, if you don't change the plan, that's not substantial law. You have to go back, rethought it, and said, they didn't like this, we're gonna change it, and then be able to come back and ask again for a lesser ask.
So,
How do you do that?
it's
No, you're absolutely can speak on it. If we can
can we
get you on a mic.
get you on?
Is this still a public meeting, or is that closed?
It's still a public meeting, but the alternate on the board. So
If you want to just, if you can come here.
it's not turning on. Okay.
Just limit the amount of times they apply, because you know that if they're going to apply again to the same item, they're going to come down because they want a better chance of it to pass.
Right.
So if you limit the amount, otherwise they're going to keep applying and just keep changing it. Say you have 2 chances or 3 chances, and after that, you're done. But you know that they're going to be a little bit
Easier with their asks.
I'm all for 2 chances.
Okay.
In anything we're talking about, I'm all for, you get 2 asks. You don't
Right.
get to keep going
Yeah,
back.
I mean, I think 3 is a lot, but 2 I think is
so
fair.
so you'd give them the right to come back, and it's going to take them 3 months, at least 3 or 4 months to come back anyway.
Right.
So it's not a question of have you changed it substantially, because if you haven't changed it substantially, you're going to get voted down the same way you did the
Well, I would
previous
still
time.
put in change, a substantial change, whatever,
Right,
however you
but-
want to define that, I
But
still would.
if we just leave that part out, that's what Jared is saying, is just leave that part out. You can come back and ask us again twice. And if you come back with the same thing that you were there with the first time, you're going to expect the same result that you got the first time.
Maybe.
Maybe, so I would say you can't come back with the same ask. Your ask has to be different.
Okay, but the question, the hard thing for an attorney to draft, and I've been a city attorney for many, many years, so I can tell you how difficult it is to draft, and I'm glad it's not my job. But drafting something to make this arbitrary determination as to what's substantial and what isn't. When Jason said something about if you came in with 7 variances and you redesigned your project and you still had 1 variance that was exactly the same, it's really difficult to draft language to say that that isn't a substantial change. So that's my concern as to how it could be.
But if
You're leaving it to staff, and
Right.
staff didn't go to law school.
I got it, but if you redesigned and you redesign it so you don't need 6 of those, it's still a different design. You've still done something that you don't need the 6. So even though you still may
But so
need
the ask is
1,
not predicated on the variance request then. It's predicated on the
the
design.
number?
the design, but it's harder to say a substantially different design, because I just think you shouldn't be able to come back with exactly the same thing
Right,
the first
right,
time somehow.
right. Yeah, no, I agree, but to
Put that into.
The language as to what constitutes material is always
If staff feels-
Materially changed, materially, okay. I think I understand where the board is going, but if we can kind of see if we can encapsulate it, are we liking the 2 requests concept?
Do we want to do that within a certain time frame as well, though? So no more than 2 within 2 years. Okay,
get 2 more shots within 2 years, and after that, you're
Okay.
and then
Well,
after
no,
that,
after 2 years, you can come back with the same request.
Yeah. Okay. And we'll work on the other part of it.
The other part of it?
Yeah.
Okay, so if I comment on the first parts? Please?
on the other suggestions. Okay.
Okay.
I don't.
I'm going to
I
be with
kind
you
of
on
like
that,
where
Doug.
we're going, so I don't.
You got a couple of us that are going to have some comments on that, but go ahead.
The place to go, if you don't like, you want to, my brain has stopped working somewhere like half an hour ago, but if you want to get reheard, we already have a magistrate who hears code compliance. Why don't we just use that same vehicle that if you don't like what happens here, you use the same magistrate, not going back to the commission is what you had before you had the board. You had people going to the commission, and they have other things to do than this, that they should go to the magistrate, who already is involved in sort of the building services system. Seems like a better answer than going to the commission.
And that was discussed by the commission.
That
as
was
well.
discussed at the commission meeting in May, and they still made the decision to have the appeal process go
Right.
to
I mean, then what you're doing is you're abdicating our responsibility to the special magistrate, that's not really his job. I mean, and you're allowing him to substitute his decision for ours.
Well, not really. You have to, it's still an appeals process. Okay, but going back to the commission is taking a step backwards.
How many folks are going through this appeal process that much?
Well, that's why we provided the stats.
No, but if it was more accessible, I mean, going to a circuit court is very different than going to a magistrate.
correct.
So if it was more accessible, I mean, I know some of the things that we've
I don't
done
think you
that
make it accessible like that.
Well, I make it hard to get to the magistrate. I mean, I just think
I'd
that
make
it should not be going back to the
appealing's
commission.
hard.
That just seems like
You have to have a criteria.
you're going backwards.
We truly appreciate your feedback on that, but the commission already gave us direction, so we'll have to keep it as it going to commission.
And truthfully, I mean, with the exception of this latter discussion, the former part was about informing you all, since it's going to impact the operation of the board in the sense of how and where these variances go after you've made your decision on those variances. I do want to make one note. Our office is in the midst of drafting the ordinance, and there was one change that we've made, and the distinction that Pat would probably appreciate as an attorney. The administrative variance, we are not framing it as an appeal to the Board of Adjustment. We are framing it as a request for a de novo hearing. So you won't have to make any decision as to whether or not the zoning administrator followed the law or whatever the case may be. You're just going to review it like any other variance request that comes before you, and that will clarify that issue.
Can you just wind that back again? So the ones for administrative decisions, we're still hearing, or we're not?
So if they're
decisions?
approved, you don't hear them.
Okay.
If they're denied, the applicant will have the option to request a hearing before you, and it will come before you as any other
A
variance
regular
request.
Correct. Correct.
Okay.
You already do that. You already have judgment as your job is now, with inspectors either going to point it out or not point it out. You have full judgment on the review of what you point out or don't point out. I can't believe the things we hear here is every problem in the city. Okay, the things we hear only what get here.
Right. No, so there's going to be a reduction on the number, presumably a reduction on the number of cases that you hear, because a number of them will be handled administratively, and it's only those people that are not satisfied with what occurred administratively would come to you, which they would presently now come to this board. So it's not a. We still have the zoning administrator still has to make the determination that you all are making, find that it meets the criteria for hardship and so forth.
Okay, so I have a question about that. So right now, when we have public hearing, and in the public hearing, people will bring up objections as far as, if that were going to be granted. So did that just eliminate the fact
It
of?
did.
Okay, so if a neighbor has an objection of something that's being done in the back room, and you just say it's done,
It's deemed to be de minimis in
And-
terms of an effect, and yes, that's,
and what sparked the fact of being taking that right away from a neighbor?
I don't know if that was part of the consideration. I think the consideration is those little minor variances where, you know, someone is seeking a variance of like less than 1 foot in the setback of the old house that has been built incorrectly. So the threshold is a very small threshold.
Right. See, I would agree with that on something that has been existing.
It is for existing structures. It is not for new
So
construction.
it's not exist, but not work to existing. It's so when someone comes and surveys and realizes he's a half an inch off.
That's correct.
Okay, but
That's
if the
for-
guy wants to do work, you're not touching that at all. Anything
That's
that has
correct.
to do with a
Okay.
permit, you're not touching.
That's correct.
So but let me ask one more question because it was about the notice. Are the administrative variances, for lack of a better word, is there going to be a notice requirement within that new code section? Because
Presently, we do not have a notice requirement.
I
in the
would
draft.
I would strongly urge that there be a notice requirement because at least then, if I'm the neighbor and you want to do whatever it is that you want to do next to me and it's an administrative thing, I would want to be at least able to submit a letter, not to come to any particular hearing or anything, but to submit my opinion as to why this is a bad idea. And I think that the neighbors deserve that. And I think it should, without question, be in any administrative variance request that neighbors within a certain distance be notified.
So I just want to go back to my question again, because apparently your question is a very different question, and your answer is different than what I thought you just said to me. Okay.
that on purpose, you know.
Keeps you guessing.
Okay. Is administrative any new work or only existing stuff you're saying is okay?
Back. I'm asking Carlin to
Go
reverse
back.
the slide
Yeah.
so we can address what.
Because that's a huge difference. Coming up with something that's been for 15, 20 years and
All right.
saying it's okay is very different.
Sure. So what we're proposing is that it applies to existing only single-family residential dwellings and the accessory uses that are seeking a reduction of less than 10%.
Yes, but that's
25%.
25% or 3
This
feet.
is still new work. So this
No.
is,
No,
This
no.
is
You said
this only
existing-
existing single-family.
Yes, but not it's a new house, but it's still new work to an existing house.
No.
I want to put an addition
No.
on.
Carport.
No, it's an existing house. It's for the existing principal structure, so if they have a fence that's been there for the last 30 years, and now they, again, same thing, they go to the title company or they look at the survey and it's a few inches off, it would be processed administratively for that
I hear you
variance.
saying that, but that's not what that says.
Without a permit, correct?
Pardon?
Unless the fence was built.
We can
without a
clarify
permit.
that.
Well,
Right.
I mean, that's what it says, not applicable to projects that were constructed without a permit. So if I put my fence up without a permit and I'm 6 inches off, tough luck on me. I don't go administrative.
They come to you.
Comes to the Board of Adjustment.
Correct.
Okay.
Right, but this still doesn't say not new work. It says existing single
We,
family.
we can make that more
Okay. I mean, if it's something that's there and it's a non-conforming and you're sort of legalizing the non-conforming, that's one thing. But you know what I'm saying? 'Cause we've had a lot of weird.
We got you. Yeah.
Okay.
Perfect.
Just, and when you approve those, are they still considered administratively approved variances? They're still called variances, like it's recorded somewhere, it's like, this was a variance that the staff approved?
Yes.
Yes.
Would be nice
So
to-
it's signed by the zoning administrator versus the chair of the board.
Okay, we have anything else?
Okay, I just wanted to wrap up with the dates, and then I'm done. So, as I mentioned, we came to you to provide the information. We're hoping to go to Planning and Zoning Board next month with the proposed ordinance, and then going to City Commission in fall for first and second reading, so September and October, and most likely having this effective in January of 2026. And now I am done.
What happened to the sidewalk thing? Did that move?
They took it away.
Did they take it away?
Yeah.
Did they not take it away?
It's not ours. It doesn't come in front of us anymore. The commission took it.
Okay, I got a different question for you. So, is this going to be presented that we presented this for feedback to the Board of Adjustment, or we dictated to the Board of Adjustment what we're doing?
Both.
Might be nice to be noticed, you know, with it.
We can be as clear as you would desire
Yes.
us to be. We've informed
I
you.
would-
We've
I would like
informed
to
you of
have
the
it as-
code changes and
Yes.
sought your feedback with regards to the section involving
On successive
all
applications.
successive applications.
If we could do it that way, so this way we're clear as far as what we agreed and discussed and
Absolutely.
what was dictated.
Can, can we possibly put in that the board felt this instead of what you're saying?
Well, we're still in the good for the city of Fort Lauderdale, so we could say it.
Pardon me?
If you want to have it on the record, we could have it on the record. We're still in session.
Okay, then I would like to do
In your microphone though, because Jamie's going to write it down.
I would like to do a communication to the commission regarding said proposed changes. Do I have to write that? Or can I just stop there?
Whatever you want.
Yeah, what is it?
I don't want to unilaterally make a communication, but I like to, I'd like to communicate that it should not go back. The appeal process should not go back to the commission. There should be a third party or another process established, not going back to the commission.
That's your.
You can go to the meeting and get up.
Okay, so that's why I'm going to discuss it, not write it.
You can go to the meeting and get up there as a
Yeah,
citizen.
we should probably go up to the meeting
But I'm
during
not
the
gonna-
discussions and say what you want to say. That's a great idea.
P&Z would be the place to make that argument. Because once it goes through P&Z, then it's pretty much going to go to the commission, unless there's something outrageous in it, it'll be adopted.
Okay, so we have a lot of great notes. We have anything else? If not, I'm going to adjourn. We can hang out after. Okay, with that said, we're adjourned. Thank you.
experienced homelessness himself on the streets in the city. We create a superior level of trust among residents experiencing homelessness, which enables us